So good morning. Thanks for joining us for this webinar on mental health issues and disability discrimination law, what employers need to know. If you've seen some of the other webinars, we will have touched on disability discrimination in some of the other topics we've been looking at, but not looked at it in any detail. So we thought it'd be good to do that now, especially with the pandemic that we've been living through and the issues in this area that have cropped up. So this is going to be an hour, so we'll be finished by 10:30. I'm presenting with Nicola O'Dwyer. You'll hear from Nicola in a moment. We are recording this, but we will stop recording before the questions. So if you want to ask a question, if you go to the bottom there, pop that in there and we'll do our best to answer it. So if we're talking about disability discrimination law, we first of all want to think about what the definition of disability. Obviously, if you've got a disabled person working for you, then there may be obligations that you are under, for example, to make reasonable adjustments, which could be costly, which could be inconvenient for your business, and therefore there may be things that you might otherwise want to avoid. So whether or not that person is disabled is going to be important because that could mean that you've got to do things you wouldn't otherwise have to do. So let's have a look at that. Now, disability is defined in the Equality Act. We'll have a look at that in a moment. There are some conditions that are automatically disabilities. So if you've got one of these things, then you are automatically classed as disabled under the Act. They're on the slide: so blindness, severe disfigurement, cancer, MS, HIV. Otherwise, there is a test that has to be satisfied, which we'll look at in just a sec. And when we go through this test, it's obvious to note that it's quite difficult when you're talking about mental impairments to assess this because it's not the same as in a physical impairment situation where it may be obvious that somebody has difficulty doing something. In mental impairment cases, of course, the effect may be invisible, and people, of course, may not want to shout about their disabilities and may indeed try to conceal it. So this can prove difficult for employers. Now, if we look on the next slide, there are many things that could be mental health conditions. There's a few examples on the slide there of some well-known ones. There are others, there are many. And as we'll come on to see, it doesn't necessarily matter what label you put on a condition. It's more the effect of it that's important from a disability discrimination law viewpoint. If we look on the next slide, we have the test. Okay, so this is set out in the Equality Act. So a person has a disability if they have a physical or mental impairment, which is a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So that's a really important test in employment law, one that us employment lawyers have to look at a lot and consider a lot to help clients. If we go on to the next slide, so applying that test in a mental impairment case, we're essentially asking 4 questions. Is there a mental impairment? Does it have an adverse effect on an employee's ability to carry out normal day-to-day activities? Is it substantial? Is it long-term? Let's have a look at these points. So mental impairment, when they first brought in disability discrimination law in the Disability Discrimination Act 1995, you had to have a recognized psychiatric condition to satisfy the test of mental impairment, but they changed that soon after. And you no longer had to show a recognized psychiatric condition. There just had to be a mental impairment. And as I say, that means the label you put on a condition, depression, anxiety, whatever, it's not necessarily that important. What's more important is to look at the effect, to ask whether someone has got a disability. Now, as we saw from the definition, the impairment must have an adverse effect on somebody's ability to carry out normal day-to-day activities. So what do we mean by that? Well, we don't mean what everyone would do on a normal day-to-day basis. It's what most people would do on a day-to-day basis. So, for instance, if you are able to play a musical instrument or take part in high-level sport, those are some things you might do on a normal day-to-day basis. That doesn't make them normal activities on a day-to-day basis under the Equality Act. The kind of things we're talking about are those things on the slide. There'll be others, but there's a few examples for you. That's really what we mean by normal day-to-day activities. And if we think about it, if you have got a mental health condition, you could well be impacted in some of these areas. So, for instance, sleeping, social activities. Those are things that could be difficult for somebody with a mental health impairment. If we go to the next slide. So what do we mean by substantial? Well, that's defined in the Act. It means more than minor or trivial. So it really has its dictionary definition. Now, something that is important to think about here is the effect of medical treatment on a condition. Now, for example, somebody may be suffering with depression, and if they take antidepressants prescribed by their GP, they may cope very well and live a normal life, and you might never know that there was any issue. But that is not the answer to whether or not they're disabled or not under the test. What you have to do, as far as the test is concerned, is ask what would be the effect of their condition if the treatment was stopped. And clearly that could be a very difficult question for an employer to ask. And we'll have a think about medical advice in a moment. What about long term? It has to have the condition must have a long term effect. What do we mean? Well, the Act says a condition's long term if it's lasted 12 months, or if it's likely to last 12 months, or likely to last to the end of life in a case where somebody's not going to live for 12 months. And it's important to think about when that test is applied, because there's a case on that, Tesco and Tennant, and the long-term effect is judged at the time of the Discriminatory Act. So we'll just look at an example there on the next slide. So I've made this up. So we've got Colin, okay, and Colin has symptoms of depression that start March of 2020, and his work suffers badly, his performance goes downhill, and he hasn't got a very sympathetic employer. And so in June 2020, he's dismissed. And in August, he starts therapy for his condition, and that goes well. And by January 2021, he's made a good recovery. So would Colin's condition be regarded as long-term, and so that he meets the definition of disability? Well, as per the case I mentioned on the previous slide there, you apply the test as at the date of the Discriminatory Act. Now, we can see March 2020 to January 2021, that's less than a year. Okay, but the Discriminatory Act was in June. So as at June 2020, when he was dismissed, was it likely that his depression was going to last at least a year, i.e. until March 2020? So you can see that's difficult to tell, but that would be how a tribunal would look at it later. They would say, well, as at June 2020, was it likely that it might last? Another twist on this is recurring conditions, of which mental impairments, will definitely feature here. So there, where you have a condition which has ceased to have a substantial effect, but which is likely to recur, then it's treated as having that effect. So, for example, in this case here, Colin may have fully recovered by January 2021. But another thing to consider is, will that condition recur? If it's likely to recur in his lifetime, then he may meet the test that way. If we go on to the next slide. So would a mental health condition count as a disability under the Equality Act? Very difficult to judge, but it's going to depend on these things. You know, the severity of the condition, how long has it lasted, or is likely to last, might it recur, and the effect on day-to-day activities. Of course, many people may have a mental impairment and it will not have much effect on their normal day-to-day activities, or certainly none that the employer might notice. So, you know, there are many people who might meet the definition, but it doesn't really matter. It doesn't affect their work. Any treatment or medication, this is important because, as I discussed, you've got to judge from the point of view of the test, what would the effect be if that medication was ceased. Now, what we might do, if we look at the next slide, to get some help in this area, is to get a medical report. If we want to find out if this is likely to be a disability, then a medical report might help. As we'll probably discuss later, a lot of times you may just assume that someone is disabled. It's just not worth the risk of arguing the point. But there may be other cases where you want to test it, and therefore a medical report might come in handy. And that can be done by the GP or treating consultant. Treating consultants such as a psychiatrist or a psychologist may have a bit more expertise in this area and may produce a more useful report. Or it may be that you get an occupational health consultant to produce a report, and most of the ones we see are usually done by occupational health. Again, with varying degrees of expertise, I think, that they bring to the question of disability, but that's usually what we look at. Anyway, a medical report may help because it may assist you to answer this question of whether someone's disabled. But beyond that, you'll probably be wanting to find out what effect it could have on activities. As I said on the slide, often it doesn't. You'll want to know how the condition may affect work, such as attendance, performance, and you may want to ask whether there are any adjustments that the consultant might recommend to assist. So that is the definition of disability. I'm going to now hand over to Nicola to look at different types of disability discrimination.
Thank you, David. Well, the different types of discrimination are direct discrimination, indirect discrimination, discrimination arising from a disability, and then an employee may also claim harassment and victimization, and also failure to comply with the duty to make reasonable adjustments. So there'll not be enough time in this webinar to address all the areas of discrimination, and therefore we will be focusing on the two areas which are regularly claimed, which are discrimination arising from disability and the duty to make reasonable adjustments. So discrimination arising from disability is set out in section 15 of the Equality Act. And discrimination from disability occurs when an employer treats an employee unfavorably because of something arising in consequence of the employee's disability, and the employer cannot show that the treatment is a proportionate means of achieving a legitimate aim. So when considering what unfavourably is, the tribunal will consider two simple questions. So they are, what was the relevant treatment by the employer? And was that treatment unfavourable to the employee? So if we think about it practically, let's think about an example. So an employee has visual impairment, and that prevents them from working as quickly as their colleagues. Now, the employer dismisses the employee basically because of their low output. So that dismissal would be discrimination arising from the employee's disability, because the disability of the visual impairment is making that the employee have the low output. Also, let's look at if an employee is suffering from depression, and because of their depression, they have quite a lot of time off work. The employee is dismissed due to the amount of time that they take off. And so the actual dismissal is not for the disability itself, but for something relating to the employee's disability, which is the need to take the disability-related sick leave. Now, there is a potential defence for the employer. So if the employer can show that the unfavourable treatment was a proportionate means of achieving a legitimate aim, and can then subsequently objectively justify their actions, then there's potentially a defence there, and they may not be liable for discrimination. So when deciding whether or not it is a legitimate aim, the tribunal will consider the balance between the requirements of the business and what the actual discriminatory effect is on the employee. The tribunal would also consider whether a lesser measure would have been appropriate to achieve the employer's aim. So one of the arguments that is used quite regularly as a way to justify the treatment towards the employee is that of health and safety. Although regularly used, it is not always a sufficient defence. It would actually depend on a case-by-case basis. Now, the employer is also required to actually have knowledge of the employee's disability, or should have actually known about the employee's disability. Therefore, if the employee actually keeps their disability silent, it would be difficult for them to then claim that the employer should have known or did know about the disability. Obviously, cases of mental health issues can be tricky when it comes to knowledge, as they may be invisible to employers, except in certain situations. Now, in those cases, it might be that the employee can show that the employer should have had knowledge of their mental health issue, which is a disability. However, although the employer is required or should have knowledge of the actual disability, it is not necessary for the employer to actually know that the way that the employee is acting is due to that disability. Also, when claiming discrimination arising from disability, the employee does not need to refer to a comparator and simply needs to show the unfavourable treatment. And now I'll pass over to David.
Yeah, just a couple of cases on this issue about knowledge of disability and an illustration of how it can be difficult for the employer. So, Department of Work and Pensions and Hall, in this case, Mrs. Hall had a psychiatric condition which she didn't tell her employer about, and she stopped taking her medication. And there were altercations at work, and to cut a long story short, she was dismissed. She brought a claim for disability discrimination, and the employer argued that they didn't know about the disability, so they couldn't be liable. Well, the tribunal were unsympathetic to that point of view. They found that the negative replies that Hall had given in a health questionnaire and her refusal to allow access to her medical records and her volatile behaviour at work were all warning signs that the employer should have taken notice of and realised that there was a disability involved in this case. So it didn't matter that the employer wasn't told, they should have known in that case. Now, Gallup and Newport deals with the situation of medical reports and knowledge. I was talking just now about getting a report from an occupational health consultant. Well, in this case, the employer relied on the fact that they'd got an occupational health report, which expressed the opinion that the employee was not disabled. At tribunal, unfortunately, that didn't work for them, because the tribunal's view was that the employer had unthinkingly relied on the occupational health consultant's opinion on this, and it wasn't off the hook because of that. It should have applied the question itself, and if it had, it would have had constructive knowledge of the disability. So there you have it. A medical report in itself doesn't necessarily get you off the hook if it goes in your favour. It's just something to take into account. I'm then going to have a look at some cases on Section 15 that shows what a very complicated area this is, discrimination arising from disability. So, City of York in Grosset involves a teacher, an English teacher at a school, who was the head of English, and his disability actually wasn't a mental impairment in itself. His disability was cystic fibrosis. So because of that, he had to take part in a very punishing physical regime of exercise 3 hours a day to clear his lungs. And anyway, there was some changes at the school which added to his workload and placed him under a lot of stress. And that stress exacerbated his cystic fibrosis. And unknown to the school, he could act out of character, perhaps show poor judgment. Now, around this time, he showed the 18-rated film, horror film, Halloween, to his pupils who are aged 14 and 15 in class. And the head found out about this, and he suspended him, and eventually he was dismissed for gross misconduct. And Mr. Grosset brought a claim under Section 15, the type of claim we're talking about here. What he was saying was that, okay, what I did was wrong, but it was my disability that caused this. It arose from my condition. And that claim succeeded, even though the school didn't have anything to point to a link between the condition and the behaviour as at the time of dismissal. But by the time of the trial, there was medical evidence that showed there was a link between his condition and his behaviour. On the question of justification that Nicola was talking about, the tribunal were unsympathetic to the school. or to the City of York Council that ran the school. They felt that if reasonable adjustments had been applied so that his workload had not been so great as to cause him the stress that he was under, then the situation could have been avoided. So their justification argument didn't succeed. Then I'm going to have a look at Hensman and Ministry of Defence, where you've got a similarly difficult case, but with a different sort of outcome. So in this case, Hensman had Asperger's syndrome, and the Ministry of Defence, on a search of his accommodation, found a video which showed that he had covertly recorded a colleague naked in the shower. And the police were brought in and they investigated, and sexual offences were brought. Now, at the criminal trial, the judge held that Hensman's behaviour was linked to his Asperger's syndrome, and so he was therefore not at fault. What he had done was not done for sexual gratification, but apparently was because of a certain fascination arising from the Asperger's syndrome. So what happened later was Ministry of Defence looked at the employment position and they dismissed Hensman, and he brought a claim under this this section of the disability legislation. Now, on the issue of the Section 15 claim, the tribunal found that dismissal was disproportionate, and they upheld the claim. They felt that a warning would have been an appropriate sanction rather than dismissal. But on appeal, the Ministry of Defence succeeded, and there the Employment Appeal Tribunal found that the tribunal below had not applied the correct test here. That on this objective justification test, they should have considered the Ministry of Defence's business needs. And key to those were the breach of trust and the fact that this had been a covert recording. So that matter was then remitted back to a different tribunal to look at the justification defence again. And I think the case settled because it's not further reported after that. Next, Shivers and Christensen, or Shivaz. So here, the employee had depression, and he returned to work following sickness absence whilst he was still suffering with insomnia linked to the depression. He fell asleep at work in the toilets, having gone to the toilet to do breathing exercises. And he was discovered by his supervisor, and he was eventually asked to submit to a drugs test, which he refused to undergo. He then went off sick again, and whilst off sick, he was asked to submit to a drugs test again. And for that one, he was just unwell and declined for that reason to take it. Anyway, the employer dismissed him for falling asleep at work and for refusing to take the drugs test. And Mr. Shivaz brought a Section 15 claim under the Act, and it succeeded. The tribunal found that his falling asleep and his refusal of the drugs tests were linked to his disability. The employer tried in that case, again, to argue a justification type defence. They relied on their health and safety policy, which pointed out that if employees didn't submit to drugs tests, then that could be a disciplinary and dismissal matter. But at trial, the HR manager of the employer rather let them down by saying that the employee posed no risk. So the justification argument was rejected and that claim succeeded. Then finally, in Burdett and Aviva, Burdett had paranoid schizophrenia, and he was dismissed for sexually assaulting colleagues and members of the public after he'd stopped taking medication and thereby not following his GP's advice, because he had not been told to stop taking his medication. He was, as I say, dismissed, and the tribunal found that although the dismissal was potentially discrimination arising from disability, the employer here was justified in dismissing because of its legitimate aim of maintaining appropriate standards of conduct and safeguarding the workforce. But on appeal, the Employment Appeal Tribunal disagreed with their findings. It felt the tribunal had not been clear in that case whether Burdett's behaviour was culpable or whether his illness had caused it. It felt that the tribunal had given too much weight to Aviva's legitimate aim as against the discriminatory effect of dismissal on Burdett. Over to Nicola.
So we're going to look at the duty on employers to make reasonable adjustments for disabled employees. So the duty to make reasonable adjustments for an employee can arise where an employee is placed at a substantial disadvantage by an employer's provision, criteria or practice, a physical feature of the employer's premises, or an employer's failure to provide an auxiliary aid. So reasonable adjustments are only for employees are only required when the employer knows of the disability or should know of the employee's disability and is aware of the substantial disadvantage that the employee is facing. So in situations where an employee has been on long-term sick leave, the employer should discuss with the employee their return to work and discuss what adjustments they would find useful and assist with their actual return, and to ultimately reduce or remove the disadvantage which is caused by the employee's disability. So, for example, an employee who is suffering from anxiety may find it hard to travel during rush hour traffic. So a reasonable adjustment may be the fact that you allow the employee to come in later and to go home earlier to avoid being in that rush hour traffic. So an employer is actually only required to make an adjustment which is reasonable. Now, what's considered to be reasonable? Well, unfortunately, there's not any definition of reasonableness, and it actually depends on the facts of each case. However, legislation has indicated that the employer should not be under a duty to take measures that would impose a disproportionate burden on the actual employer. Now, some examples of reasonable adjustments are set out in the Employment Statutory Code of Practice, and they include such things as adjustments to premises, as I've said in my example, altering the hours of work, maybe providing information in audio or braille format, allowing the employee to work in a different location, maybe home working, and removing some of their duties and providing those duties to an alternative employee, or actually just having someone there that can support the employee. Allowing the employee to have time off for appointments, for treatments or rehabilitation. Could be adjusting redundancy criteria, modifying the disciplinary or grievance procedure, or it may be that it's a combination of all of those things, just to help the employee to be able to return to work. Now, the government provides an access to work grant, and this may be provided to the employee to assist with implementing changes within the workplace. So a grant could be provided to help with purchasing special aids, paying for the adaptation of the premises or equipment. And also there is a mental health support service, and that provides assistance to employers to help understand mental ill health and how they can actually support their employees. Finally, you're not actually required to make reasonable adjustments for a non-disabled employee who is associated with a disabled person. The reasonable adjustments are only required for a person that has the disability themselves. David will now take you through some case law on this.
Yeah, thanks, Nicola. So as Nicola just went through there, there's lots of things that could be a reasonable adjustment, and it stands for tribunal at the end of the day to say what's reasonable or not. We're going to look at a few cases here that just show that they've decided on some quite novel ones, which who knows might arise in your workplace. So first of all, Archibald and Fife and Wade and Sheffield Hallam. Archibald and Fife is not actually a case involving mental impairment. It was a road sweeper that, because of a physical condition, could no longer do their job. Anyway, what that case is authority for is that it may be a reasonable adjustment to transfer an employee who's no longer able to do their job because of their disability to another role, even perhaps one at a higher grade, without requiring them to go through the process of a competitive interview. And you can certainly think of cases where that might be relevant, where somebody's got a mental impairment and maybe they can't do their job, and you're thinking of transferring them, but you want them to go through a process of selection, which could be difficult because of their mental impairment. It may be much more difficult for them to do that than for someone who doesn't have that impairment. So anyway, that in that case, they said that was a reasonable adjustment to do it. However, in the case of Wade and Sheffield Hallam, the tribunal came to a different answer. Same point of transferring an employee to an existing vacancy. In that case, it was held it wasn't a reasonable adjustment to do that because there the employer had a real concern that they were unsuitable for the vacancy. So the cases show it's not necessarily going to be reasonable in every case, but it might be a reasonable adjustment in some cases to transfer someone to an existing vacancy without having to put them through the application process. Creating a new role, so slightly different. In this case, Southampton City College, Randall, there the employee couldn't do their job because of their disability, and they wanted the employer to create a new role for them. So that's a further step, obviously, because there's no vacancy there. But in that case, it was found that the employer had failed to comply with the duty to make reasonable adjustments by not considering creating a new post, taking account of the employee's disability. This was slightly unusual, though, in that this case, the employer was carrying out a reorganisation, and it admitted that it pretty much had a blank sheet of paper so far as job specifications were concerned going into this reorganisation. So the point is they could have done it in this case. So the tribunal found that creating a new role was a reasonable adjustment. Homeworking. So rather topical. This is a bit of an old case though now, and I think we probably have a different result, but let's look at it. Department of Work and Pensions again, and Wilson. So Wilson was agoraphobic, and she requested homeworking, and this was rejected. And a tribunal found that that was a failure to make reasonable adjustments, but she failed when it went to appeal, because the Employment Appeal Tribunal disagreed with that outcome. The appeal tribunal felt that the evidence showed that the job, which involved interviewing members of the public face to face and viewing confidential files that others needed to see, couldn't be done effectively from home. So, that reasonable adjustment failed in the end. But query today whether that will be the same result. I mean, as we've come to get used to, a lot of us, doing the job from home, even if you have got to talk to people on video, or you do have to look at confidential information, which is often over the internet via a secure portal. You know, these are things that can be done. So possibly a different outcome today, but that's a few years old now, that case. Hensley is an odd one. So this is about reinstatement, and briefly, Hensley suffered with depression. He was a police officer, and he resigned. And in that case, it was considered to be a failure in the duty to make a reasonable adjustment by not reinstating Hensley where he had resigned whilst depressed. The employer should have taken that into consideration and made a reasonable adjustment and allowed reinstatement in those circumstances. And in Hill and Lloyd's Bank, here the Employment Appeal Tribunal upheld the tribunal's finding that it was a reasonable adjustment for the bank, in this case, to give Hill an undertaking that either on her return to work, she would not have to work with certain individuals who she claimed had bullied and harassed her, or alternatively, to pay her off with a severance payment. So in that case, Hill had reactive depression, and that undertaking was deemed to be a reasonable adjustment, even though one of the grievances against one of the colleagues hadn't been upheld by the bank, and her appeal against that finding had failed. So it was still held that that undertaking was a reasonable adjustment. So quite a novel case, that one. Now I'll hand back to Nicola.
Thank you. So let's look at mental health itself and look at some statistics. So in 2018-19, the Office of National Statistics found that 17.5 million working days was lost to sickness, absence for mental health. And obviously the pandemic has caused higher numbers of individuals to actually suffer from mental ill health. And the UK Household Longitudinal Study, which is a study that seems to be set up for the pandemic and is continuing, found that there was an increase in the number of adults suffering from mental distress by 8.1% from the numbers between 2017 and 2019. And in addition, the BBC reported that 1 in 5 adults experienced some form of depression during the early part of this year, which is more than twice the number of people suffering depression prior to the pandemic. So therefore, with these numbers and statistics, it's likely that you will have someone in your team or department who may well be suffering from mental health illness. And obviously, it's important that you are supportive of them. Now, prior to the actual pandemic in 2017, a review was undertaken by Stevenson and Farmer. And in that, they set out a 10-year vision to reduce the number of mental health issues that are caused by work. Now, the review actually proposed 6 mental health core standards, which could be implemented across all workplaces. Now, they've not become part of any legislation, but I think it's particularly useful at this time just to look at them, and it's a good place to start when you're looking at things that you could implement within your company. So they are the production of a mental health plan, which would set out your approach towards mental health illness, developing the mental health awareness among employees, potentially by providing training, the encouraging of open conversations with managers and colleagues about mental health, and making managers aware of the support that the company can offer employees who feel that they are struggling. Making sure that employees are aware of potential opportunities and how they can further their career, and so how they actually fit in to the company. Also making sure that they have that good work-life balance. So maybe making sure that they're not working late every evening or weekends, and potentially when they take holidays, they are actually on holiday rather than working as well. Again, just promoting effective people management, and maybe routinely monitoring mental health and well-being by providing questionnaires which can be completed anonymously. Now, I think an interesting question would be is how many employers actually do any of these things for their employees? Well, obviously I can't answer that, but a recent poll undertaken by Mental Health First Aid England indicated that 29% of employees had never had a conversation with their line manager about their mental health. Now, is that because the employee themselves feel that it's embarrassing to raise that, or do they feel that their manager's unapproachable, or could they feel that it's a taboo subject? Well, it is more important than ever now to reach out to your employees because they could be suffering from issues caused by the pandemic, as well as the normal day-to-day issues. So the pandemic could have caused the employee to actually be suffering from after effects from having the coronavirus. They could be suffering from grief as they have lost loved ones to the coronavirus. It could also mean that they have concerns about job security or elderly relatives. And potentially they could have ongoing issues with schooling and having to homeschool, and the whole issues of isolation, which is currently being talked about in the media. So the big question is, how should you approach this with your employees? As obviously it's an extremely sensitive subject, and you don't want to cause your employee further upset or any embarrassment. Well, ACAS, in response to the pandemic, have produced a guide on coronavirus and mental health at work, and this provides some assistance. So we're just going to look at some of their points. So the ACAS guide recommends that you should have private conversations with your employees and check how are they feeling, How is their work going? If they have any concerns about coming to work, and if they are working from home permanently, do they have the right setup at home? And whilst you're in that meeting with the employee, whether that be in person or via video call, it's important just to sort of keep an eye out, really, to see if there are any signs indicating that they could be suffering from any mental health illness. And this could include the fact of the employee appearing tired, anxious, potentially disinterested, emotional, or withdrawn. And other potential signs in their general work, which could alert managers, is a general lack of interest in their work. Obviously, the increased sickness, absence, lateness. So even if they're working from home, are they logging on late? And changes in the employee's usual behaviour. Obviously, this is a bit more tricky to monitor when they are actually working from home, but something to be aware of. And is there potentially a slip in their standards? Now, if you are concerned about any of your employees, again, the ACAS code or guide says that you should address it with them by arranging a private conversation with them as soon as possible, and make sure that you approach it in a positive and supportive manner. Now, if the employee does actually confide in you about suffering from a mental health illness, then obviously you should support them, so discuss potentially how you can help them at work, and signpost them to different organisations that could help. And I have added a list of resources to the end of this webinar. So employers could also arrange for mental health champions or mental health first aiders, which would be the first port of call for the employees to go to. They could also arrange an employee assistance programme, which could provide counselling and help for any employees. And again, it's just another place for the employees to go to. And the other thing that you can undertake is a risk assessment for stress factors. Now, as I'm sure many of you are aware, employers have a legal duty to protect employees physically, but also from stress at work. And therefore, it's important that you not only carry out a physical risk assessment, but also one for stress factors. Now, there's some templates on the HSE website, and we're just going to look at one of them in the next slide. So this is a template risk assessment which is on the HSE website and is based on a financial services company which has 40 employees. So the risk assessment identifies 6 areas of work which could cause stress to the employee. So if we just look at them separately, so we've got the demands, so you need to be looking at workload, work patterns, and the work environment. You have control, so how much say does the employee actually have in the way that their work is completed? And support, so how much support is actually provided by managers and colleagues, and do they have all the resources that they need to be able to do the work that they have? There's also the aspect of relationships. Are there positive relationships between employees and their managers, or between their colleagues? The role, Does the actual employee understand where they fit within the organisation, and where they can go from there? And also change, because that can be unsettling to employees. I mean, how does the company manage change for employees, and also in regards to the organisation generally? Now, this brings us to the end of the talk, and as I said, here are the list of resources, and so you may wish to look at these when signposting employees to somewhere to find help. So this actually brings us to the end of the talk, and we will have a look at any questions that you may have.